If you're an employee and you're asked to sign a covenant not to compete as a condition of employment, there are a few things you need to know. South Carolina is a state that actually disfavors covenants not to compete. So covenants not to compete tell you that you cannot generally compete with the employer for a period of time after you leave. So covenant not to compete, for it to be valid, has to hit 3 prongs. Prong number 1 is its scope. The scope of the covenant not to compete has to be directly related to the industry in which you're in. For example, if you are in retail sales and the covenant says that you can't do sales other than retail, well then it's past the scope. So the scope has to be very narrow to protect the employer. Prong number 2 is its duration. Pretty much you can rest assured that any covenant not to compete that goes beyond 2 years for an employee is not going to be enforceable in the state of South Carolina. Lastly, and this is the one that gets people generally, is its geographic footprint. So if a covenant not to compete states that you are working, let's say, in Charleston County, but it prohibits you from operating or competing anywhere in the state of South Carolina, if the company for whom you work really only has a basic footprint in Charleston, South Carolina, then its geographic scope is too broad and will not be enforceable. Keep this in mind. We do not allow blue penciling in the state of South Carolina. What is blue penciling? That's where a judge can say, yes, the employer said the state of South Carolina, but if it was just limited to Charleston, it would be enforceable. We don't allow that in South Carolina. Basically, remember this. The judge will throw out the baby with the bathwater. What I mean with that is if the covenant fails on any of those 3 prongs, there is no covenant. So as you're drafting covenants not to compete or reviewing a covenant not to compete, less is more. What I mean by that is it's better to have a covenant not to compete that's narrowly defined to fit what it needs to be. If it's too broad, it's not valid and it will not be enforced in South Carolina. Again, South Carolina disfavors covenants not to compete. So if it's not narrowly drawn to fit its particular purpose, it will not be enforceable.